That was a very long introduction, but I'll just go ahead and start. I'm April Glazer, and I'm an activist here at the Electronic Frontier Foundation. And today is the International Day Against DRM. At EFF, we think you should have the right and ability to make full use of your stuff. And that means to tinker and reuse and resell, improve, break, and lend things that you own. That's why EFF has been fighting against digital rights management for more than 15 years. So today we're joined by EFF staff attorney Mitch Stoltz, international director Danny O'Brien, and our global policy analyst Maira Sutton for this live discussion. So just a quick background, DRM stands for Digital Rights Management, and it's a bit of technology that hardware and software manufacturers, publishers, and copyright holders use to control the way we use the devices and media that we own. Now the idea is to limit users' ability to copy the content without permission. But DRM does much more. It shapes how people tinker with and share devices, software, music, movies, and that people have legally paid for, and it's a problem. The effect of DRM on your rights has grown thanks to the U.S. Digital Millennium Copyright Act, which makes it a crime to try to bypass DRM or even spread the knowledge of how to do so. These laws, called Anti-Circumvention policies, are now being exported around the world in international agreements like the Trans-Pacific Partnership Agreement. So I'm actually going to start with kind of a little U.S. background on this. So I'm going to ask Mitch a question. Mitch, I'm wondering, what are the anti-circumvention laws in the U.S.?
So here's how the law works in the U.S. This is the Digital Millennium Copyright Act that you mentioned. It was passed in 1998. And the basic rule is that it's illegal, not necessarily criminal, but it can be, but it's illegal to in the words of the statute, circumvent a technical measure that effectively controls access to a copyrighted work. What does that mean in the real world? Well, the boundaries are a little bit fuzzy, but generally speaking, this is breaking some sort of encryption or some sort of access control. It can't be a mere label, or even as a technological label that says, please don't copy this. It has to be some kind of technological protection that makes it difficult to access a work. And then what's circumvention? It isn't simply ignoring a signal, like you're getting a TV signal or video signal with a bit activated in it, which is a flag that says, please don't copy. It has to be actively bypassing some sort of access control. So the classic example would be decrypting it or breaking the encryption on it. Now here's where it gets tricky. The DMCA also bans trafficking, which is buying, selling, transferring devices or software that do this kind of circumvention. So both building the tools, distributing the tools, and using the tools are all potentially made illegal by this. And this is the tricky, even more tricky part, under some circumstances at least, it doesn't matter if you're doing the circumvention or building the tool for a purpose that is otherwise completely legal. The tool itself can become illegal under the DMCA. There are a host of exceptions, both temporary and permanent, but I will save that for later in this conversation.
Great, thank you so much, Mitch. And speaking of different kinds of anti-circumvention provisions that we see, not just in the U.S., but around the world, I was wondering if, Maira, you could talk to us a little bit about the Trans-Pacific Partnership Agreement. Let us know what it is, and also, how does DRM fit into what we know about the TPP?
Sure. So to give you a little bit of background about what the TPP is, it's the Trans-Pacific Partnership Agreement. Over 29 chapters are in this agreement, and one of them is the Intellectual Property Chapter. 12 countries are negotiating the TPP, and several of those countries are very opposed to the U.S.'s very restrictive demands that they're pushing for, especially in the DRM, the anti-circumvention sections of the Intellectual Property Chapter. So some of the most extreme provisions include some of the things that actually Mitch mentioned, because many of the TPP's DRM provisions actually mirror essentially the DMCA. And actually, to give you a little bit of history on that, the DRM provisions that are in the United States were actually passed because we had to become compliant with a UN treaty. An assistant for the Chamber of Commerce, Bruce Lehman, he tried to pass laws around DRM in the 90s, but it wasn't really popular in Congress, and so then he sort of did an end run and got many of these very extreme proposals passed at the UN level, at the World Intellectual Property Organization, or WIPO. Once it was in these international treaties, these copyright treaties, then they were able to go back to Congress and say, hey, we passed these international treaties at the UN. We need to make our laws compliant with them. So many of these rights holders, the Hollywood and the book publishers, many of those interests were able to use the secret, undemocratic processes that unfortunately, are the reality at these international policy-making spaces, and then use that to then pass really awful DRM laws in the United States. Now we have this, quote-unquote standard in the United States, which we've seen for many years is broken. And we're pointing to that, the U.S. Trade Office is pointing to that and saying, hey, other TPP countries, you should adopt these laws into your own laws because this is what we've been doing here in the United States. What the problem is that in the United States, we're trying to reform the DMCA and especially these DRM circumvention laws. But if we pass the TPP, then again, they could say and point to the TPP and say, well, look, this is an international standard. All these other countries agree to it. We can't be non-compliant and we can't reform our laws. And then, of course, there are all these other countries that don't have these DRM laws, and then they would have to adopt it as well.
So
that's the overview. I could go into the more details about what DRM provisions are in TPP, but that's sort of the politics there.
Well, let's also hear an overview about other places where we've seen DRM crop up, like the World Wide Web Consortium. And Danny, I was wondering if you could kind of tell us a little bit about, what is the World Wide Web Consortium, and how does DRM fit into the picture there?
Sure. So, can you hear me?
Sure can.
Then I'll go ahead. So the W3C is really the brainchild, I guess, of Tim Berners-Lee. It's a consortium that was set up after the web had become popular in an attempt to put forward the standards and the systems that made the web in an open way. So in many ways, it's the way it works sort of mimics the ideals that we kind of imagine for the modern web and the modern internet. Recently, which is to say about 2011, there was a push within the W3C by one of its members, actually a few of its members, but primarily Netflix, Microsoft, and Google, to introduce not a DRM standard, but a sort of box that you could put DRM into. One of the real challenges for anyone in the modern age who wants to convince people that digital rights management is necessary is the huge counterexample of the web, where the content that we see you can use, you can link to, you can take apart, you can even save and reuse for under fair use. Obviously, Hollywood and other major content providers who have sort of put in their support for DRM, and were many of the organizations that funded that initial DMCA provision, would like to have DRM baked in to the open web. And so they put forward a standard called Encrypted Media Extensions at the W3C. So encrypted media extensions would bake in DRM to the modern web browser. And we see this as incredibly problematic. I mean, there's already DRM protected content in plugins. So if you go to Netflix's online version or Amazon Instant, that's almost deliberately set aside from the web. That's something that doesn't fit in to how we expect the web to work. By baking in encrypted media extensions into the very newest standards for the web, it's almost like saying that this is acceptable or even necessary for content to succeed. And that's part of the double whammy of how DRM tries to insinuate itself into the modern media world. So on one hand, we have this sort of soft sell, which is companies going, we absolutely need to control your computer and put this equipment into it and make sure that you don't have final veto over what goes on your machine. Otherwise, you won't be able to get cool movies. And so that's the soft sell that's going on in the W3C. And then you have the iron glove, the iron fist in that velvet glove, as it were, where you have the criminal prosecution for DRM. And those are the two things that EFF worries about so much, right? Is that perhaps it would be okay if digital rights management was competing on an even playing field, where people could take it or choose it, and also choose to challenge it or use fair use principles to sample and cope with it. Except that's a criminal offense, and so is even talking about how to do that. So I guess what we've talked about here is these three wings of it. We've seen the most mature version of DMCA anti-circumvention provisions in the U.S. We've seen the expansion of that in the international.
Okay, is Danny frozen for other people?
Yes.
Okay, Danny, so I don't mean to cut you off, but I think the tech just cut you off. So I just want to remind people while we're making sure our connections are working that they can chime in and ask any of us here at EFF questions using the hashtag #DayAgainstDRM on Twitter. And we'll be bringing those questions here for our webinar participants to answer. Danny, do you want to finish your thought? It seems like your connection has restored.
Oh, I think I did. So.
Okay. Okay. Well, one thing that really struck me what you were talking about was how companies have participated, in the legal processes that have brought DRM into law. And I was wondering if Mitch could talk a little bit about that in the context of DMCA. How have these large companies that use and want to use DRM participated in getting DRM codified into the DMCA? That's the Digital Millennium Copyright Act. And if you could talk a little bit about the exceptions and what the next round of exceptions might look like.
Sure. I think a lot of the original impetus for this anti-circumvention idea, which ultimately made it into the UN copyright treaties and into U.S. law and into the law of many other countries, was the kind of the brainchild of the major entertainment companies who wanted to be able to apply technical protections to the digital entertainment and have it be illegal to break those. Another area where they get involved regularly is in this 3-year exemptions process, and I'll say a bit about that. The DMCA in the U.S., and I understand this is similar in at least some other countries, it has a handful of permanent exceptions, instances where it's legal and allowed to circumvent DRM, digital locks, and so on. The permanent exemptions, at least in U.S. law, they're very narrow and they're pretty hard to use. Such that if you make a misstep, it's possible to be liable in a civil suit or a criminal prosecution. So they're not all that easy to use. There's an exception for nonprofit libraries, archives, and educational institutions. There's one for encryption research. There's one for security testing. There's one for reverse engineering of software in order to discover information needed to make that software interoperable with other software. Those all exist, but they've rarely been tested in court, and we suspect they've rarely been very helpful to people. The other part is the temporary exemptions. Every 3 years, the U.S. Librarian of Congress, really it's the Copyright Office, which is part of the Library of Congress, holds a proceeding, a series of hearings and written comments. It's a little bit like litigation, where they ask people to propose new exemptions for groups of copyrighted works that are difficult to use legitimately because of the law against circumvention. So we are now on the 6th, I think, the 6th 3-year round. The result of each one of these proceedings is a set of exemptions that protect people for the following 3 years. And then at the end of 3 years, according to the rules, there's the slate is wiped clean. There could be a new set of exemptions, but they're not necessarily the same ones. They don't automatically continue from cycle to cycle. And in the early days of the cycle, they granted very few and very narrow exceptions. They've gotten a bit more generous in recent years. So the current set, and these were the ones that were passed in 2012. They cover certain things related to accessibility, screen reader software, closed captioning data. They cover jailbreaking or rooting of mobile phones, but not tablets, interestingly, even though they run the same operating systems. They briefly covered unlocking of mobile devices in order to use them on other networks, but that one expired, which led to a big public outcry and potential action in Congress to fix that one. And then they cover breaking DRM on DVDs and online subscription video specifically for the purpose of using clips for documentaries, amateur video, and I guess sort of nonfiction video productions, not general fiction video. Again, these exemptions are very specific, but it does cover basically amateur video of the type you'd see on YouTube that involves mashups or sort of fan video. That's the current set. We're this fall. It will be the beginning of the cycle yet again, and I know EFF will be proposing new exemptions, and other organizations will as well. I'll leave it at that.
Can I add something?
Yeah, please. So, Maira, what do you want to add?
Sure. Yeah, I just want to emphasize how resource-intensive this process is for us and for every organization that's involved. You know, we have to do, as Mitch mentioned, we have to ask for the same exemptions every time. As our technologies are evolving and as our uses and our experience change every year, let alone every 3 years. So it's really sort of restrictive and backward for us to have to do this process every 3 years and to ask for the same ones and then to focus on new ones that are really harmful for users. And so even as we are doing this process in the United States and we see that this really is onerous for users, we are exporting the same DMCA rulemaking process to other countries through the TPP and other trade agreements. And other countries are resisting it, likely because they see how in the United States it's slow and it doesn't make sense, and they are both trying to expand how long those temporary exceptions are and just to sort of resist that system itself by saying we should be able to create our own mechanism to decide if we want to make temporary or permanent exceptions for users to be able to break DRM.
Right, and it seems like, with temporary exceptions, people might create business models once they think something like bulk cell phone unlocking is legal, and then 3 years later, that might become illegal, and whole businesses and industries, and as well as people who count on this for their art and their research, all of a sudden doing something that's illegal that just last year was perfectly legal to do. And Maira, I was
that's
wondering
a big problem. I'm sorry, April, if I could
Please.
add, and just because unlocking was such a great example of this.
Yes.
The unlocking a phone in order to switch wireless carriers really has nothing to do with even what was sort of the original intent of the DMCA, which was to prevent copying of copyrighted works like entertainment. Now, the argument is that a cell phone contains software, and that the carrier locks are, in a sense, protecting access to the software. But really, it's not about protecting the software or preventing people making copies of the software. Really, it's about protecting the business model that locks cell phone subscribers into a particular carrier. Really not the intent of the law. But this comes up in other areas occasionally, too. There have been attempts to use the DMCA to prevent third-party garage door openers, to prevent the recycling of laser toner cartridges. The courts are split on this, unfortunately. There's a really good argument that the DMCA simply should not apply in those circumstances, but some courts have said that it does, and that makes for this sort of uncertainty that you mentioned with, say, recycling of electronics with third-party or compatible electronics with aftermarkets. All of those things are impacted by the DMCA.
Right, and it seems like the people who are benefiting from the DMCA or from the DRM provisions are these big companies, and I was wondering if Danny could talk a little bit about the way these big companies have participated in getting DRM into our products all over the world, and if there's any way to get them to have a change of heart.
Well,
or to not use DRM.
Sure. I think one of the challenges here is that DRM always has a monopolizing pressure on it, right? Because one of the things that you have to do in order to impose DRM is get an agreement along all the channels. Like every single part of the network has to buy into the DRM process. And that wouldn't normally happen unless you had some player in the market having a monopolistic position, at least. It's certainly not coming from sort of consumer demand. I mean, as old EFF fellow Cory Doctorow says, no one actually goes out and demands that they should be able to do less with their media and less with their computers. The biggest pressure comes from environments where you have a few major players who control a large percentage of the dominant media. So certainly in the case of the arguments that go through in somewhere like the W3C, and before that, when EFF and others have taken part in other standards committees that were introducing DRM, for instance, when DRM was proposed as part of the broadcast TV standard for digital TV in the United States. The people really pushing for that, and we use the shorthand now Hollywood, but it's worth kind of unpicking that. The 3 or 4 major situations and say, look, if you don't implement what we want in digital rights management, then we'll simply withdraw our content. We won't put it forward. They claimed that they would do this to television, and right now they're claiming to do this on the web. Now, it's interesting what happens when you call that bluff, because I think the lesson of the web and the lesson of modern digital communications is that you have to enter into a negotiation with your existing business model and how this new system works. And no one successfully sort of taken their content and stormed off. Even when you have firewalls in newspapers and things like this, paywalls, you have to like concede some ground. The problem with DRM is that you're not talking to the end consumer. You're talking to the middleman. You're talking to Microsoft, or you're talking to Apple, or you're talking to Netflix. And what happens is that that's where you get to bake in the DRM. Now, the funny thing about this is it doesn't really help the former monopoly, the large media organizations in the first place, because what they're really doing is creating a new monopoly, because they're ceding the power over who gets to see their content into other companies, like Apple, like the DRM vendors themselves. And I think if there's any hope for convincing companies, major companies, to consider other ways of delivering their content, it's what happened in the music industry. Because what happened in the music industry in the early 2000s is they went, we absolutely need DRM as a condition of what we want to do. Apple, who just introduced the iPod and the iTunes Store, said, okay, we don't necessarily think DRM is a good idea, but sure, if that's what you want, we'll put it in. And within a few years, Apple was holding the purse strings from the music industry, because the music industry couldn't get away from Apple without abandoning DRM. Now, in the end, that's what they did. In the end, we got a system with MP3s where there isn't really DRM in the primary distribution network for downloadable files. And frankly, we don't really have it in streaming either. I mean, there's sort of DRM in streaming, but it's more the inconvenience of recording a stream, I think, that stops people from breaking it than any sort of super clever DRM within their system. I hope and pray that that's what we'll see in these places that are currently imposing DRM.
And so, Maira, I was wondering if thanks so much, Danny, and I was wondering, keeping things on the international side, but, Mitch talked a lot about the anti-circumvention provisions in the DMCA and how complicated they are, and I was wondering if you could talk a little bit about the specific anti-circumvention provisions that are likewise in the TPP. You're muted.
Okay. So as Mitch mentioned, or as I mentioned earlier, the U.S. DMCA rulemaking process, where we have to ask for the same exceptions to break DRM every 3 years, that model is trying to get exported to other countries by the United States, the U.S. Trade Representative's Office, despite the fact that it's been very problematic and resource intensive for us to figure out ways to free content and make sure that users have proper rights. So there's a DMCA rulemaking process. There are very narrow exceptions for people who are blind, for security researchers, for libraries to break DRM for purposes that are, and oftentimes are granted as fair use in several other countries. In particular, in the United States, we have a pretty broad category for security researchers to determine whether a device or content might be harmful for a user's privacy, for instance. Unfortunately, that itself has not been enough to secure those researchers from liability for breaking DRM. But the provisions in the TPP are even narrower, so it might even be more risky for security researchers to do their work to make sure that users are safe on our devices and platforms. And in general, the US is trying to make it very hard for other countries to pass permanent exceptions. For example, if you are a person with a visual disability and you want to free an ebook or change the format of a DVD, if you yourself do not have the knowledge to decrypt, to unlock that content, that you won't be able to take advantage of a fair use that exists in your country because of, as Mitch and I believe Danny mentioned earlier, about the fact that the tools and the knowledge to free content is itself illegal. To distribute that knowledge is illegal. And when that's illegal, then even if it's legal for certain people to break DRM, they need to have the expertise to do it themselves because they can't get that information from the internet. So, so even the flexibilities that exist in the TPP aren't enough to protect users. Fortunately, there is some positive movement at the again at the UN World Intellectual Property Organization that gave us the great DRM proposals in the first place. There is a treaty for the blind that was signed in Marrakesh, I believe now 2 years ago, and for over 10 years, blind groups, access to knowledge groups, EFF, Knowledge Ecology International, and many groups fought really hard for over a decade to have a permanent exception for people with visual disabilities to break DRM and to do other things to make sure that they have access to content, because there's a huge dearth of books and content that is available for people with visual disabilities. Unfortunately, a lot of those Hollywood companies, the studios, book publishers, even companies like Caterpillar, a industrial equipment company, and several other companies fought really hard against exceptions for people who are blind because they were afraid that that would whittle away at copyright. It's the strongest agreement that we've ever had in international law that explicitly protects users against restrictions of copyright to break DRM if you are a library or an institution that is trying to help people with visual disabilities to gain access to books. But as I mentioned, as long as the tools and the knowledge is illegal, it's still very difficult for people to take advantage of that treaty and of the benefits of fair use. And right now there are some efforts to pass more treaties like this. So one for libraries and archives, for libraries to break DRM for fair uses, and also for school and educational institutions. And right now they're in the very beginning stages, but hopefully we'll see enough pressure from everybody to pass better international law to protect users and protect people's rights to access content.
Awesome. So it seems like that there's some stuff that people can do, some action that they can take. And I want to get to that in a minute, but now I want to take a question from someone that has chimed in on Twitter. User Scott _ Annesley has asked, and this might be a good question for Mitch or Danny, what effect does DRM bear upon business practices? Is it a major effect upon economic cooperation or public benefit? So kind of a general question, but can one of you take that?
I could say a bit about that. One of the real effects of laws like the DMCA, the Anti-Circumvention laws, is to give copyright holders more negotiating power over other people in the market, other players in the market, other people in the distribution chain. That the major content producers like the movie and TV studios can insist on some level of DRM in digital distribution, and that insistence is backed up not only by the contracts that they have with distribution companies like cable systems, like internet providers or internet platforms. It's also backed up by this potentially criminal penalties of the DMCA. So it essentially puts a thumb on the scales of these business negotiations in favor of the copyright holders over the distributors and the technology providers.
Awesome. Thanks so much. And go ahead, Danny.
I was just going to add something that people often don't get about DRM, which is there's a lot of talk about creating a DRM that would work for everyone, a sort of open DRM in the same way as we have open standards for the internet, where anyone could sit and implement the DRM that the content producers want, and everyone would be happy. That would allow innovation to continue. And there's a real problem with that, which is that at the heart, DRM is a system to stop you from doing something. So it's even if you can describe how to implement DRM, it's very easy if you're just writing DRM yourself to just take out the bit of code that says if somebody wants to edit this for fair use purposes, then say no. You can just remove that. You have to have some way of enforcing DRM, of compelling people to do it in a particular way. And the way that the DRM vendors and the content providers have sort of struck on to do this is partly through the enforcement mechanisms of the DMCA, but mainly it's by locking down DRM in things like software patents and intellectual property. So the idea is that if you try and implement DRM in a way that they don't like, they can sue you, and you have to sign an agreement with them to get that intellectual property. It's called hook IP, and I think the more you think about this, the more insidious it becomes as a challenge. So when we fight DRM in the W3C, it's because anybody who wants to implement the DRM that's apparently going to be part of the web has to come to a contractual agreement with the content providers themselves. They have to sign a contract. And I mean, I can assure you that if Netscape and AOL and all the people who were making browsers at the very beginning of the web had to go and sign a contract with Hollywood or book publishers or whatever in order to create the web as we knew it, it would never have got off the ground. The very point of the internet is it's what we call permissionless innovation. There's nobody you have to ask to be given the chance to create your app or create your website. And DRM at its heart is a permission demanding system.
Okay, yeah, well, thanks for all that, everyone. And it looks like we have another question from Twitter, which kind of piggybacks off that last one, and maybe Maira can answer this, or Mitch. It looks like user Narcissus wants to know what major companies are making a big profit from DRM by blocking rights to readers. Maira, you're muted.
Oh, sorry.
If you could start over, that'd be great.
That's an interesting question because it's not really quite clear if they are making a huge profit from DRM. Maybe Mitch can correct me, but you know, you really are robbing users of being able to do various things with content and devices that they've purchased, and you know, I think a lot of consumers and users don't, as much as they could maybe, pay attention to, you know, the rights that they might not have otherwise if DRM was not on those things that they've purchased. But you know, it is a way, as Danny said, to sort of monopolize the market and only make certain kinds of content operable with certain kinds of devices, and so it does sort of force people to you know, purchase things in a certain way because they have no other choice. So maybe Mitch has another answer to that.
Sure. Well, Danny mentioned this as well. I don't think companies are profiting directly from DRM other than by selling it to copyright holders. But historically, and again, I think this was the real purpose of DRM in many cases, was to create monopoly lock-in. So when Apple iTunes Store was selling DRM-encrusted music, that was creating a monopoly lock-in to the iTunes store and to Apple, because that DRM would only play on Apple devices, and it could only be transferred to Apple devices. And it was in part the music labels, the copyright holders themselves, who abandoned DRM in digital music, in music downloads, just to get out from under Apple's monopoly control. That's, I think, also a large motivation behind this DRM proposal in HTML5. Is for some people, it's to lock internet users and video producers into using the technology of a particular company, and for others, it's to break that sort of control.
Great. Well, that actually answers a question I was about to ask. Somebody asked about, what are the concerns with DRM being in HTML5. So thanks, Mitch. I want to remind people that they can ask us questions. We'll be taking just a couple more using the hashtag #DayAgainstDRM on Twitter. Before I go to another question from Twitter, I was wondering if Maira, Mitch, or Danny, you guys can talk about what people can do who are concerned about DRM in their products. Is there actions that people can take? Is there a way to participate in the DMCA rulemaking or in stopping the TPP or the W3C somehow? I'll start with Danny on that.
Well, I think, one of the more important things you can do is actually vote with your pocket, is actually advocate and request and constantly argue for DRM-free products. And we've seen one of the great things about the Day Against DRM is that everybody who sells DRM-free stuff has a chance to mention that, because often it's quite hard to know whether you're getting something that's locked down. So I think definitely voting with your whatever your currency of choice is a really good step. I think when you have something like happening in the W3C, I think that it's really important to speak up. I think one of the biggest challenges we have is that those who would like to have a lockdown ecosystem, their power is kind of concentrated. It's pretty easy for the MPAA to send a single representative to these organizations or to make their pitch. And the rights that we're fighting for are very dissolute, well, not dissolute, distributed. They're connected to each of us individually, and so we have to act collectively in order to assert those rights. So I think one of the really important things you can do is to find out other people who are concerned and join with them.
Okay, great.
And let me add,
Mitch.
Yeah, the next round of the exemptions rulemaking at the U.S. Copyright Office is going to kick off this fall. There will probably be a public comment period. It's probably actually going to be beginning of 2015 if they follow their previous pattern. But we will publicize that on the EFF website, and we will be telling people how to get involved. It is open to the public. Anyone can comment. Anyone can attend the hearings. Anyone can send written comments, and they were in the last round, that is the one that concluded in 2012, the comments from the general public were hugely influential, especially in preserving our exemption for jailbreaking and rooting mobile phones. The Copyright Office got about 700 comments from the general public on that question. Not really a lot in the grand scheme of things, but enough, I think, to really sway their thinking about the importance of exemptions like that.
Well, considering most people that take part in these rather opaque rulemaking processes are lawyers and paid lobbyists, I'm sure it's very refreshing for the Library of Congress to hear from the public about how these laws and how these exceptions really affect people on a everyday level. And Maira, I was wondering if you could talk a bit about the TPP and what people can do to stop that if they're concerned about, the exportation of DRM and U.S.-style DRM laws across the world.
Sure. So as I mentioned, many of these international policy-making venues are unfortunately designed in a way to insulate themselves from public participation and public input. And so many of the actions that we've done at the EFF is very focused on lawmakers, and sometimes to the trade offices, but oftentimes they're much more, beholden to the, big content interests than the public. So we have two actions, one of which is, both of them are U.S. focused, but one of them is to call on Congress members to call for a hearing and to really examine what is going on in the TPP, and to figure out what discussions, what positions the U.S. is laying out on the table on our behalf, and doing so in a way that could really tie ourselves from being able to reform our copyright laws, our DRM laws in the future. The second one is a action to stop fast track. Fast track is a mechanism that allows the president and his U.S. trade representative to essentially negotiate trade agreements and only have to get approval, the ratification of the agreement from Congress over a yes or no vote with barely any time for proper hearings over, all 29 chapters, broad range of issues. So it's really, really crucial that we stop fast track, because without fast track, the other countries don't really want to agree to provisions if the United States Congress can end up amending those provisions. And essentially, they're already negotiating TPP as if they have fast track, so they need fast track to get TPP approved. So stopping it and taking action and letting other people know about why and how these copyright provisions are in this trade agreement is really crucial. And right now it's the TPP is sort of in a standstill, but it's really due to everyone being very vocal, taking to the streets, talking about it on Twitter, and demanding that their representatives do not sign off on the sweeping, secretive, corporate-driven agreement.
Wow, so there's a lot people can do, and it seems like a lot of awareness that still needs to be raised, and so that's why we're so happy to be participating in the Defective by Design's Coalition International Day Against DRM and holding this webinar with some of our experts in-house. One thing I want to also underline is that, clearly U.S. policy matters here. Right, it's being exported, it's used as a model, and so many companies are based in the U.S. So I think it's worth noting that there is actually a piece of legislation that was introduced called the Unlocking Technology Act that we support at EFF, and we urge other people to support too. If you go to our website, you can sign the petition and let your representative know that it's very important that these kinds of common sense laws, like the Unlocking Technology Act, that would go a long way.
Sorry,
go ahead.
April, should we say a little bit about what that act does?
Yeah, I was wondering if you could get into that, Mitch.
Sure. And then my apologies, but I need to drop off.
We'll wind down.
Very briefly, the Unlocking Technology Act would create the general exemption that the DMCA needs. It would make circumventing DRM for a purpose that's otherwise lawful, not illegal. So circumventing for any sort of fair use or for lawful research or building of compatible products or anything unrelated to copyright infringement would be legal. That's a really important step, and we hope folks will support that. I apologize, I need to drop off, but thanks very much, April, and thanks everyone.
All right, I think we're all going to sign off now. We had one more, question from Twitter, but I think that'll be answered in a number of our blog posts throughout the day. We will be posting about DRM around the world and here in the United States. So follow us throughout the day and follow the hashtag Day Against DRM to see what other folks are doing, including the Free Software Foundation that invited us to participate in this. We want to thank them for that. Thank you so much, Maira and Danny. Do you guys have any closing things you want to say before we all sign off? All right, I'll take that. Danny, you sure? You usually do.
One of the comments that thank you, April. One of the comments that people say in this is like, well, how comes you're using Flash to do your system on DRM? And it's a fair point. Proprietary systems don't have to implement DRM. And I think there's a lot of work going on right now in a lot of venues, including the W3C, that people can contribute to build a really good ecosystem for doing systems like this that don't rely on proprietary software and don't need DRM. So.
All right, thank. I'm muted. Okay, well, that's a really good thing to bring up. Thank you so much, Danny and Maira, and I think that's going to close us off. I hope everyone has a great day and continues to raise awareness throughout the day about DRM on the International Day Against DRM. Take care.
Thanks, April.
Thank you, Maira.
Thanks, April.